The settlement agreement come in that morning, $2.4 million for his client. An amazing settlement, a number nobody in the case had even considered or said out loud 18 months earlier. Opposing counsel insisted it be signed by the end of the day. The economic terms were exactly what had been negotiated. The recitals were clean. The payment schedule was fine, but it was the confidentiality provision that was wrong. Not obviously wrong, wrong in the way that only reveals itself to a mind that is actually reading and analyzing rather than scanning when tired. Welcome to the Free Lawyer Podcast. I'm your host, Gary Miles. An attorney's focus is not a soft skill. It's not a character trait. It's not a matter of wanting it badly enough or trying harder than the lawyer across the table. It's a condition. Your thinking is either protected or it is not. And the document on your desk does not care which. I'm going to tell you about an attorney I will call Michael. He caught something in that settlement agreement that would have cost his client a great deal. And the reason he caught it had nothing whatsoever to do with him being a better lawyer than the man who drafted it. It had to do with what time of day he read it and why. What I'm going to give you today in the next 20 minutes are two versions of one morning and the single structural difference between them. I'm going to talk about why the most expensive mistakes in your practice are often the ones you will never, ever find out about. And we're going to discuss the one asset in your practice you've never priced and the fact that you give it away first every single day. Before I tell you what Michael actually did, I want you to see the other version of that morning, because that is the version most of us are living. That's the version that I lived. And in that version, as far as anyone can tell, the day goes fine. So let's talk about the version of the story that actually goes wrong, where he signs the agreement sent to him by opposing counsel. That morning starts off the way almost every other morning starts, and it's the morning that goes wrong begins by going normally. He gets to the office at 7:50 a.m. The phone rings. Not unusual. Different client, different matter. He handles it. He gets it resolved. It seemed urgent to him because the phone rang because it was loud, not necessarily because it was important or urgent. After the call, he dives into his email inbox. By 10 o'clock, 11 things he's handled that arrived in that inbox without really being asked for. None of them were the settlement agreement. The morning goes, the afternoon goes, two associates need him. Paralegal pops head in the office and has a question. A partner wants support on some matter. He eats lunch at the desk, answering an email about a different case entirely. The whole day seems to have been spent on the phone or answering quick questions or responding to emails. He feels like he's been on a hamster wheel, feels like a punching bag. By the end of the day, he's tired. He gets another email from opposing counsel. Where's the signed settlement agreement? The other lawyer's waiting. So at 6:40, he opens the agreement for the first time for what he tells himself will be a careful read. So what does he do at 6:40? He looks for the number. The number is perfect. He scans the rest. He sees a confidentiality provision. We all know they're boilerplate. They all sound the same. Everybody knows that. He signs the agreement. And here's the part that should sit in your chest. He never finds out. Nobody calls him the next day or 3 weeks later to tell him what he gave away. The cost of that signature is real and permanent, but often invisible to him for the rest of his life. And boy, that was me. That was me completely. That's how I practice law. Answering the emails, answering the phone, supporting my staff, answering questions from partners, responding promptly to opposing counsel, all day on the phone answering emails. One thing after another, feeling like I never ever stopped, and by the end of the day, The thing I really need to get done, the matter I really need to move, nothing had happened yet. It was still sitting, waiting for me to do something. So tired, exhausted, and distracted because I really want to get home, I then tackle the one thing that was most important. I never learned of any errors in those things, but that's not what matters. It's the uncertainty and the fact that it doesn't have to be that way. See, many mistakes we make in our profession don't announce themselves, but most do. If you miss a deadline, the court tells you. If you blow a statute of limitations, the carrier tells you. This one does not. There's no invoice, there's no phone call. The file closes clean and you move on believing you did good work. And that's the version that most of us are living today. The busier we are, the more in demand we are, that's what our life looks like. So, back to Michael. What did Michael actually do differently that morning? I want to be careful here because the answer may disappoint you. It's not impressive. And that's exactly why it's so important. See, this is not a story about ability. This is a story about architecture. Michael is no better or no worse than any other lawyer. He's not smarter than the attorney who drafted the provision. In raw ability, they're probably identical. See, the temptation is to listen to what I'm saying today and see it as a story about talent and skill and focus. Resist it. It's not about talent. That will lead you nowhere useful. It's about how we use the first 90 minutes of our day. See, 4 months earlier, working with me, Michael had set up a protected first block in his day. The first 90 minutes were saved for the important work, for the work that required focus and analysis. Really had the best use of his brain and his intellect. And he saved them for the hardest substantive thinking on his desk. Nothing else was permitted in. No email, no phone, no walk-ins, no interruptions. Complete focus. He handled communication in defined windows later in the day, rather than continuously across all of it. He didn't allow himself to be interrupted every time he's working on something important. He would return all the calls, answer all the emails in certain windows of the day. So this Michael did not look at the release for the first time at 6:40 p.m. when he was exhausted and tired. Instead, he opened at 8 a.m. He had a clear head. He looked at it in a block that he had saved exactly for things such as this. Existed specifically so that documents like this one could be read the way they deserve to be read. There's nothing heroic in that. It's actually very unglamorous. But it's repeatable, even if it is, frankly, quite boring. The catch in the release did not come from a burst of brilliance. It came from a boring structural decision made months earlier and defended every day since. And when I realized what I was doing wrong in my practice, and I began saving those first 90 minutes for the projects and matters that required my complete focus, my best use of my intellect, it made a real difference. I would save it for answering the motions or drafting the complaint. And I had to say no to the interruptions for it to work. I had to say, no, I'm not going to return that call while I'm working on this. I won't look at my email. My door is closed and my staff and partners know not to interrupt me. And trust me, it's not easy. It's not easy. We train ourselves to be always available and committed and responsive. And closing our door and ignoring our email and not listening to the phone is really quite hard. But it's so important. See, you cannot decide at 6:40 p.m. to be a lawyer whose mind is clear. That decision was made for you hours earlier, or it was not made at all. Now let me tell you what the protected block actually made visible, because this is where the story stops being about a schedule and starts being about a $2.4 million settlement. The confidentiality provision in the story was drafted broadly. Wow, way too broadly. Broadly enough that it did not just cover the terms of the settlement. The other counsel was trying to get it to cover matters that weren't even part of the case. It went much further than the underlying facts of the dispute. It bound not only the client, but the client's ongoing business relationships and future statements about matters that had nothing whatsoever to do with the money changing hands. Read quickly, it seemed like standard language, but read carefully, it was extinguishing something that had never been negotiated, had never been paid for, and was not part of the case or the settlement. The pause is the whole story, not the catch, but the pause. Michael read the agreement carefully, twice, and on the third pass he saw it. But at first, it didn't really resonate. He did not immediately understand what he was seeing. He understood only that something in that sentence didn't sound right. It was reaching further than it should. And then he realized that the reach was too precise to be accidental. And here's what matters. That tired lawyer at 6:40 p.m. with opposing counsel waiting doesn't pause. He pushes through. He tries to get it done. And the reason he pushes through sounds like discipline. There's a deal on the table. The client wants it closed. The language is probably fine. Opposing counsel wants it back that day. I'm going to push through. But what did Michael do instead? He paused. He read it a fourth time. He read it carefully. He saw what was wrong. Then he picked up the phone and called opposing counsel. The provision came out. The agreement was corrected, and the settlement closed at the same number it would have closed at anyway. And his client kept something he did not know he was about to lose, he was about to give away. See, that's the kind of error that only a thoughtful, focused mind can see. These are not the errors you catch by being careful. Careful is what you tell yourself you are being at 6:40 p.m. But they're errors you catch when you're fresh and focused, instead of tired and exhausted and in a hurry to get home. See, the catch was not a moment of brilliance. It was the return on a boring, structural decision we made together 4 months earlier. Michael did not outthink the lawyer that morning. He simply arrived at the document in a condition that the other version of him who signs it never had access to. Now I want to take on the conclusion most attorneys draw from a story like Michael's, because it's the wrong conclusion. And drawing it will cost you years. I know, it cost me years. The attorney who drafted the provision was not incompetent. He was doing his job aggressively, maybe even too aggressively on behalf of his client. That's maybe what he's paid to do. Michael was not better than him. He was not superior to him. But the difference was never between Michael and opposing counsel. The difference was between Michael and the version of Michael who reads that provision at 6:40 in the evening. One of them had built a practice where his best thinking is protected by design. The other read the agreement in whatever condition the day happened to leave him in, tired, frustrated, exhausted. Same lawyer, same ability, same dedication, different architecture. We're trained to believe that our outcomes come from effort and ability. Trust me, they're important. That's the whole architecture of our legal education. So when something breaks, what do? We work harder. We add hours. We work later. We try more. And those don't fix it, because our problem was never, ever a shortage of effort. See, you cannot out-effort a broken design. You cannot out-effort a broken design. You need a good structure. And this is my story, and I lived it for years. I worked so hard, and I never caught up. Never. I couldn't catch up, not once. So I did the only thing I knew how to do. I worked harder, and then harder than that, and it never worked. All it led was to me being frustrated and tired. Not one time did it work. The pile never got smaller. The days never got shorter. Nothing changed until I changed the structure of the day itself. You know, those hard years were so frustrating. My work was not getting the best of me, and neither was my family. I got home too late. I was tired, I was exhausted, and I came home distracted and frustrated. But when I started protecting that morning 90 minutes, everything changed. I got more done. I was more productive. I was more focused. At the end of the day, I had actually accomplished real work on my most important days. It wasn't easy making the change. It was hard to protect that time, but it works. Effort is really not the most important asset. It never was. Effort is what you spend when you don't have a design. And it's actually the most expensive thing in your practice. So if it's not effort, then the question becomes what it actually is. And that starts with one honest answer. So tell me this. When does your best legal thinking actually happen? When? During your day. Not when you wish it happened. Not when it used to happen, back when you had fewer files. When does it happen now in the practice you're actually running? And by that I mean, when do you work on your most important matters with complete focus, diligence, and intention? What time of day? What day of the week? At night when the office is quiet? On weekends when no one's around? Many attorneys can't answer that question because they've never actually looked. I built the attorney's productivity power assessment for exactly that purpose. It takes about 4 minutes, and it will tell you where your best thinking is currently going. You can find it at garymiles.net, or there's a link in the show notes. You may not like the answer, but that's actually the point. Because here's what most attorneys have never done. They never price the thing they're giving away first every single morning. Because there's 1 hour in your day that's worth much, much more than all the others combined. And every morning, without purposely deciding to, you hand it to your inbox. You give it to your emails. You know your rate to the dollar. Everybody knows your billable rate. And at the end of the day, if we bill 7 hours, it's the same rate applied to all 7 hours. It's the same. Every one of you could state your hourly rate right now without looking it up. That number is seared in your memory. But now tell me this. What's the value of the 1 hour of your genuinely best analytical thinking? Not billable time, not time in answering routine emails, but your true focus time, your thinking time. The hour that produces the catch. The hour that lets you build the theory of your case. The hour that lets you craft the one argument that may turn the whole matter. See, you can't actually price it because it's not priceable. That hour is worth more than every other hour you will bill this year combined, and you know it. And yet that's the first hour you surrender to your inbox every single morning without deciding to, without noticing. I did a poll on LinkedIn a month or so ago, and over 90% of the attorneys, that's the first thing they did, go through their inbox. And that's actually the design error at the root of most of our practices. See, we treat our hours as interchangeable units. 6 billable hours are 6 billable hours, but the hour in which you can see the unfair language and a confidentiality provision, and the hour in which you cannot, are not the same hour. They're not worth the same. They bill identically. They appear identically on your statement, but they're not the same. Protected thinking time, our focus time, it's not a comfort. It's not a perk you earn once things calm down. It's actually the highest leverage asset in your practice. It's what sets you apart as an attorney. And most attorneys spend it on triaging their email inbox. This is a design problem, not a discipline problem, not a commitment problem, and it's solvable in a way that trying harder never has been. So I want to end with the way Michael actually tells this story, because it's not the way you would expect. It's actually the reason I made this story the focus of today's episode, because I've not been able to put it down. Michael does not tell the story as a triumph. He tells it as a warning. What unsettles him is not that he caught it. It's how close he came to not catching it. It's knowing that the catch depended entirely on a structural decision he had made 4 months earlier and could just easily not have made. And underneath that is the question he cannot put down and I cannot forget. How many times in all the years before did something similar cross his desk at 6:40 in the evening when he was tired? And how many times did he miss it and sign the agreement? See, he will never know. And that's the nature of it. Most attorneys will never learn what their reactive days have cost them. The losses do not announce themselves. There's no invoice, no phone call. You're not told when your best thinking was unavailable. You simply proceed as though it was. The number in Michael's story was $2.4 million, but the number is not the story. The story is that his mind was in the right condition one morning when it truly mattered most, and that this was not luck. This was a structure. This was a plan. So let me leave you with the only question that really matters, and it's not about Michael. Somewhere in your practice, there's a document that arrived while the phone was ringing, or while your mind was elsewhere. An agreement you read after the day had already taken most of what you had to offer. A provision that seemed reasonable once, at the hour when everything seemed reasonable. You'll never know which one it was. But what you can do is to decide, starting tomorrow morning, what condition you are in when the next one arrives. I'm Gary Miles. Practice law with purpose and live life with freedom. One more thing before you go. I offer a complimentary coaching call, no pitch, just two attorneys talking honestly about how your practice is actually designed and whether that design is serving you. You can book it at GaryMiles.net or in the link below. I will talk to you next time about how the losses don't announce themselves, a story about architecture and not ability. Until then, practice law with purpose and live your life with freedom.